Some of the most common mistakes that I see in premarital or postmarital agreements are the following. Probably the most common is a lack of adequate financial disclosures. So maybe parties drafted up the agreement on their own and just signed it and thought that was good enough. And while that's close, you also need to exchange financial disclosures. So things like bank account statements, tax returns, property documents, insurance documents, things like that, in order to make sure that the agreement is rock solid. And often people miss some of the financial disclosures or miss an account or a piece of property entirely, which ultimately might lead to the premarital agreement being unenforceable in court. Another common mistake that people make when entering into a premarital agreement is doing it too close to the wedding. So there's no magical time when you have to do it before the wedding. There's not a day limit set out by the Colorado courts or anything like that. But generally, if the parties agree to a premarital agreement too soon, too close to the wedding, the court might find that one party was under duress. If one party puts a premarital agreement in front of the other person the day before the wedding, says you need to sign this before we get married, it's understandable that that person might feel pressured into it. All of your family and friends are already in town, you have your dress hanging up already, and you feel like you have to. And that can lead the court to think that one party was under duress and again lead to it being unenforceable in court. It's important to choose an attorney who has premarital or postmarital agreement specific experience because they know the common pitfalls. They know what counts as adequate financial disclosure and what doesn't count as adequate. They know what provisions are often left out. They know which provisions are the most challenged in court. So they can help you make sure that yours is as rock solid as possible and takes all of those possibilities into account the first time when drafting it. You absolutely can draft your own premarital agreement in Colorado. After all, it's just a contract between two people, but having an attorney certainly helps make it more enforceable. Again, it's not required to have an attorney write or review a premarital agreement for it to be enforceable, but the success rate of enforceability goes way up when an attorney has drafted it because the court knows that you were advised properly, that you were given a chance to think about all the things that might happen, that you were given a chance to review those financial disclosures, and that you were guided along the way. Another common mistake might just be leaving too much out. Maybe you wanted to keep it short and sweet, and while that's a great idea, there are a lot of possibilities that you need to consider and include in your premarital agreement, even if they might never happen. For example, have you considered what would happen if one of you passed away instead of in the event of a divorce? That can be important to include in your premarital agreement to make sure that your property and your money and all of your accounts pass along the way that you want them to. Another mistake that I sometimes see is a premarital agreement and a will that are incompatible. Maybe your premarital agreement has a certain provision for what will happen with a piece of property, and the will says something different. So we need to make sure that the premarital agreement takes that into account, and we always know which documents provision controls. If you have any other questions about premarital or postmarital agreements, you can reach out to New Leaf and book a free case evaluation.